number 28, stroke 113, stroke 2023, Senoe Ishmael Matswara, Thabo James Dipol, Nandipa Magudumana, Matinyani John Masukel, Diego Franz Makota, and Natasha Johnson. The matter is set down for today and tomorrow for bail application. The state is ready and it's an opposed bail application. You shall note from the record that I did not include the names of the respective legal representative for the reason that I know of one change, and therefore I would rather prefer that each of the legal representatives confirm their attendance and representation as a basis before we proceed.
Thank you.
Mr. Court, please, Your Worship. Your Worship, I confirm my appearance on behalf of accused number 1 as well as accused number 7.
Thank you, Mr. Murori. And are you ready to proceed with the...
Indeed, so we are ready, Your Worship.
Thank you.
Thank you. My names are as indicated in the previous appearance, but for record purposes, I'll repeat. I'm Sutla from Matamedi. I confirm my appearance on behalf of accused 3 in this matter, and I further confirm that I am ready to proceed with the bail application today. Thanks.
Thank you.
Court pleases, Your Worship, the record still reflects, Your Worship, that I am for accused number 4. Duly briefed by Machini Mutlo Matenis. And Your Worship, with your permission, I would like to actually address the court regarding the state of readiness. I'm not sure if the court will give me platform to do it now or after having gone through the process of establishing the legal representation for the rest of the other accused.
Yes, please keep that in abeyance.
Thank you.
Yes.
As a court basis, Your Worship, I confirm appearance on behalf of accused number 4 as well, as a court basis.
May it please the court, Your Worship, I confirm that I appear on behalf of accused number 6, and that indeed we are ready to proceed with the bail application. As it pleases you.
Yes, Mr. Kwenane, before you resume your seat, may I establish as to accused number 6, what type of glasses is he wearing?
Can I just approach
Please.
him and just make sure?
Yes.
Your Worship, my client says that they are sunglasses. However, he is unable to cope with the glaring light. And if the court could allow him to wear them.
I do order that you remove the sunglasses in court.
Court, please.
Thank you.
As the court places, Your Worship, as it is on record that in the previous occasion, I appear on behalf of the accused number 8. I just want to withdraw today as the accused number 8 had enlisted in the service of my learned colleague, Mr. Border. So Mr. Border will be taking over from today henceforth, my lord. As a court basis.
Thank you.
May I then be excused, Your Worship?
Yes, before that, Miss Nastasia Janssen, do you confirm that you have terminated the mandate of Advocate Ditabe. Thank you. Advocate Ditabe, you are therefore excused from the proceedings.
As the court pleases, Your Worship.
Thank you.
As pleases the court, Your Worship, I confirm my appearance on behalf of accused number 80, Worship. I'm Mr. Gary Bota from Gary Bota 30s. I confirm I'm coming today on record, Your Worship. I confirm I'm ready to proceed in this matter. This is a bail application. It's an ex parte application. My client is in custody, and we want to start the proceeding as soon as possible, as it is the court.
Thank you. Yes, before I let the stage to further address, Mr. Damini, let me get back to you.
Thank you, Your Worship. Your Worship, the record will reflect that we only came on record last week for the first time on this matter. And we were actually ready by then to proceed with bail application. But however, Your Worship, after extensive consultation, it then emerged that there is a very material evidence which is very crucial in relation to accused number 4's matter, which is also crucial in the interest of justice that it must be procured in order for accused number 4 to be able to make a decisive decision in relation to this matter. But Your Worship, not only with regard to that, I also need to place it on record. May I proceed, Your Worship?
Yes.
I also need to place it on record, Your Worship, that accused number 4, because of the nature of the importance of that particular information, is also looking at the possibility of exploring other avenues of ventilating her rights outside this particular court by way of other processes, amongst others, including applications. So it is for that reason, Your Worship, that we are saying the initial decision back then, before the emergence of this crucial information and or evidence that has since surfaced, we were ready, but in the interest of justice, we are saying we request our right in relation to bail to be reserved in line with the provisions of 60 subsection 1, that her right with regard to an application for bail be held in abeyance and be exercised at the subsequent or any other proceedings, provided that we will be in a position to carry out our mandate. In other words, Your Worship, all that we are saying, we are not abandoning the right of accused number 4 to apply for bail. Section 60 subsection 1 provides that her right to apply for bail exists throughout the proceedings. So we are not abandoning. We are merely saying, let that right be held in abeyance. Let the matter against accused number 4 be rolled over to the same date in which the main matter is coming. I'm saying this, Your Worship, being mindful that this is actually an interlocutory application. The main matter is actually in 3 working days from today, which is the 16th of May. So we are saying the matter in respect of accused number 4, today we request that it be rolled over to the 16th. And then at an appropriate time, when accused number 4 is ready to bring an application, arrangements will be made with the state for accused number 4 to move her bail application. And I suppose that even for the presiding officer or another presiding officer to come and hear her application, by virtue of the fact that obviously your worship would have been exposed to some of evidence which perhaps the state might be leading, which might also be or casting on accused number 4. For that reason, your worship, our request is simple, is that we are before you. We were of the view that we will proceed with this interlocutory application, but for unforeseen reasons, we are not in a position to do so today. We request this matter against accused number 4 to be rolled over to the 16th, and then at an appropriate time, decisions will be taken as to when and how will accused number 4 exercise her rights in terms of the provisions of the Criminal Procedure Act. If there is anything which the court would want me to address on, your worship, I will be ready to take questions from the bench.
Yeah, given the fact that matter was adjourned until today for bail application, I just want to establish, is there any distinction to say the accused is provisionally abandoning his bail application and to keep his bail application in abeyance? I just want to get a clarity so that my records can properly reflect.
Yes, I don't remember me saying she is abandoning provisionally. I have not made that word at all. All that I'm saying is that her rights, she has got rights which she was hoping that she will be exercising those rights today. But due to unforeseen reasons which I've already placed on record, she is saying, I don't want to exercise those rights now. I will make up my mind in the near future. My rights are still intact, are still in existence. I will make a determination at the right time. So the question of abandoning, we are not abandoning bail. We will make the decision at the right time. I don't know if I answered you.
Yeah, but I simply wanted a distinction between keeping his application in abeyance and to provisionally abandon. Just a distinction.
If that is your understanding of abandoning it provisionally, I have no problem with that. But all that I'm saying is that her right be held in abeyance. That will be exercised in due course, as and when all the information that we are in the process of procuring has been procured. Simple as that.
Thank you. State, is there any reaction in the submissions by Mr. Tamini?
As much as I'm still confused, but nonetheless I can confirm that this morning Mr. Mashini Mutlowu, who also happens to be appearing for accused number 4, approached the prosecution, and there is a written request for some information in which the state will then have to respond to that request. That's all that I can say. Like I'm saying, we only received it this morning, a request for information that will then inform their decision in terms of the way forward. That's a brief conclusion.
Thank you. Mr. Dlamini,
Yes, sir.
in short, after listening also to the reaction of the public prosecutor, your application is granted.
Thank you, sir.
Thank you.
May we be excused?
Yes, you are excused.
I take it that accused letter will then come on the 16th.
Yeah, let me firstly just get clarity as well as to whether you are in at idem with the state with regard to that aspect of a date.
Or was the court looking at giving us a different date, Yoshi?
No, I was just saying application for Meta to be kept in abeyance so far as her bail application is concerned. That application is granted. Then let us deal then with the second leg with regard to the date as to whether you are in ad idem with the state with regard to that aspect alone. Mr. Matuko, there is an application that the bail application of accused number 4 be kept in abeyance until next week, the 16th day of May, 2023.
Worship, I miss a point. The application for bail, insofar as I'm concerned, is not on the table until they make a decision.
All right.
The application for a postponement is the application in the main matter, the charges that accused 4 is facing, and the request is that matter be rolled over until the 16th when the other accused will be appearing. That is my understanding.
Yes, I take it appears.
Not the bail application.
Yes,
So
it appears
there's no
that
talk of bail application anymore at this stage.
All right, it appears you are in the same page with Mr. Damin. I can see he nods.
It's exactly what we are saying.
So, with regard to date, it's fine.
The date is fine.
Thank you. Thank you. Then Mr. Damene. Okay, Mr. Machine.
No, Your Worship, I'm covered. It was the question of requesting to be excused
All right.
from further proceedings. as
All
a
right,
court
both
basis.
Mr. Damene and Mr. Machine Motowung, you are both excused.
As a court basis.
Thank you.
Worship, I would then request that at this stage, insofar as accused number 4 is concerned, that we already maybe postpone that matter until the 16th, so that we are left with only those accused that intends applying for bail. That she as well then be excused, the same way as her legal rep has already been excused.
Okay.
That's my request.
Mrs. Magudumana, your case is hereby remanded until the 16th day of May, 2023. It is for the purposes of investigations. You will remain in custody until then. Thank you.
As a court basis.
Thank you.
As please the court, Your Worship. Your Worship, the court shall note from the charge sheet that there are a few charges against the accused persons, 3 or 4 of which are relating to corruption, which the annexure will indicate that it was committed on the state alleges common purpose, and it was committed by a group of people, and therefore in terms of the relevant schedule, that will be a Schedule 5 bail application, as it please the court, Your Worship.
Mr. Matoko, so that I be on the same page. May I hand the charge sheet to you so that you can indicate as to, in respect of each, as to what's...
I do understand the predicament of the court. In fact, even on previous occasion, I omitted to alert the court to the fact that the initial charges, there was substitution of those charges. The court shall be aware that when we started with the matter, there was a charge of murder, but when we substituted the charges and outline what the charges are in respect of each of the accused, the court shall note that from the substituted charge sheet, there is no longer a charge of murder. In essence, what I'm trying to say is, insofar as the charge of murder is concerned, it may be regarded, or the state provisionally withdraws that charge of murder. That is the first aspect that I wanted to clarify. And my apology that at the last appearance, we never placed on record that the charges have since been substituted. And I can then go on to outline the different charges. In terms of count 1, and that would be in respect of accused 1, 3, and then 4 and 5, which are not before court. In respect of the accused before court, the relevant accused will then be accused 1 and 3, and that is the count of fraud. Count number 2, that will be accused 1, 3, 4, 5, 7, and 8. Violation of a body. Count 3, that will be 1, 2, 3, 4, 5, 6, 7, and 8. It will be the contravention of section 3B, read with various sections of the Prevention and Combating of Corrupt Activities Act 12 of 2004. That is now corruption in terms of giving of a benefit. And the state, as indicated, we are alleging common purpose. Count 4 will be against accused 1, 3, and 7. That will be corruption in terms of receiving of a benefit. That is now in contravention of 3A of the Prevention and Combating of Corrupt Activities Act. Count 5 will be in respect of 1, 2, 3, 4, 5, and 6, and that is fraud. Count 6, it will be in respect of 1, 2, 3, 4, 5, and 6, and that will be arson. And that will also include 7 and 8. My apology, Your Worship. The substituted charges were prior to the arrest of 7 and 8. And then count 8 will be contravention of section 115B, read with sections 1 of Act 111 of 1998 in respect of accused 1, 2, 3, 4, 6, 7, and 8. That is aiding and escape. Count 9 will be in contravention of section 117A, read with section 1 of Act 111 of 1998, and that is in respect of accused number 5, who is not here, which is escaping. Count 10 will be contravention of section 115E, read with sections 1 of Act 111 of 1998, in respect of accused number 4, who has since been excused, that is for harboring and concealing an escaped offender. Count 11 will be in respect of all the accused, and that is the defeating the ends of justice. Count 12 will be the charge of fraud in respect of accused 1, 2, 3, 4, 5, and 6. And count 13 will be in respect of accused number 1 only, that is of corruption in relation to the receiving of a benefit. Count 14, that is in respect of accused 4 and 5, who are both not here, that will be also for corruption, for the giving of a benefit. Count 15 will be in respect of 1, 4, 5, and 7, also corruption, for the giving of a benefit, and that is in the furtherance of a common purpose. Count 16 will be in respect of accused 1 and 7 only, and that is also for corruption, for receiving a benefit in the furtherance of common purpose. Those are the charges, Your Worship.
Thank you. Right, Mr. Murori, do you confirm the schedule?
I do confirm the schedule, Your Worship. I take no issue with it. Allow me to show that to Your Worship, please.
Mr. Kwenani?
I will dispute Schedule 5 and will maintain, Your Worship, that our client, accused number 6, matter should be classified as under Schedule 1. And the reason why we are saying that is precisely because this charge actually excludes the fraud that pertains to the giving of a benefit of 2.5 million. So we will actually contest that particular schedule, unless there are aspects of the charge that we are not aware of, which we would like the state to enlighten us all. Because our client is actually charged of fraud that pertains to the body, claiming of the body, and arson, and contravening section 115B, and defeating the ends of justice. We are going to dispute the schedule. God bless this motion. I wonder if there's anything that the Worship would like us to deal with. God bless.
Yes, I intend not to react or to respond. The public prosecutor who alleges will
Absolutely,
respond.
we'll deal with that.
Thank
God
you.
bless this motion.
Okay. Mr.
Number 8 with no objection, Your Worship.
Thank you. Any reaction from the state with regards to the argument by Mr. Kwenani that for his client, matter will be a Schedule 1?
No, I don't agree. In the sense that even the fraud that he is talking about has indicated that the state has alleged in the charge sheet the issue of the furtherance of common purpose. Even in that respect, that he only refers to fraud.
Mr. Kwenani, do you want to further your argument?
I'm inclined to, however, in actually saying that we should further argument, it was going to mean that we should actually request the certificate which indicates that particular schedule from DPP, which would delay the proceedings. So we are only going to not continue actually with that particular matter pertaining to the schedule in the interest of progress. We will, however, proceed with our argument.
So you abide.
We will abide in the interest of progress only.
Thank you.
For reasons.
Thank you. Mr. Murori?
Mr. Court pleases Your Worship, perhaps firstly and before I commence, a bit of housekeeping. There was a meeting between the defense and the state as well as the chief magistrate. Well, that would be the defense excluding the legal representative for accused number 8, where certain aspects were canvassed, particularly as far as the media coverage of these proceedings are concerned. My learned colleague, I have not had sight of the addendum that was issued by the learned chief magistrate, but I have subsequently been placed in possession thereof. And just for proper housekeeping, Your Worship, I think what is relevant for today's proceedings would be 1.3 on the said addendum, which reads, with your leave, Your Worship, on the days of the hearing of the formal bail applications, no live recordings of the proceedings shall be permitted. This includes the testimony of witnesses called, the testimony of the accused persons, and the respective cross-examinations that will follow. And perhaps, Your Worship, just to ascertain from the court that that has in fact been canvassed with the media houses, and for them to confirm that there will be no recording of any proceedings that are to follow here after, Your Worship. Mr. Court, please.
Yes, Mr. Mako?
Yes, I agree with the sentiments of what was said by my learned friend here. I must, however, point out that it was brought to my attention that subsequent to that there was a meeting this morning between the media house and the chief magistrate, and the outcome of that meeting I'm not familiar. I was not briefed. I do not know what was agreed. Maybe as a starting point we need to first verify what this morning's meeting's outcome and what it entails.
Thank you.
As it pleases.
As the court pleases, Your Worship. Well, just like my colleague, my learned colleague, I'm really uncertain about this meeting. We are never privy to the discussions of that meeting. As the representative for accused number 1 and number 7, we stand by the addendum that was issued, Your Worship.
Yeah, to keep nice and sweet, because I am briefed by the chief magistrate. The meeting, it was only about the interpretation of 1.3. The meaning of 1.3 of the addendum. And it is clear, it is straightforward. It prevents a live recording during the testimony of the witnesses, cross-examination, re-examination, and so forth. That was it, Mr. Matloko. It was just to interpret, because it appeared that there was a confusion as to what is meant by clause 1.3 of the addendum as to the guidelines in this proceedings.
Mr. Court, please, Your Worship. With that being the case, then I would accept that the media houses would need to be warned that their cameras must be switched off, and there should be no live recording of the proceedings that are to ensue, Your Worship.
Yes.
And taking from the court's wisdom, I leave it in the court's hands. Mr. Court, please.
Yes, for the sake of progress, to the media house, I will reiterate and repeat the guidelines in these proceedings with regard to your broadcast. It is hereby ordered that on the days of the hearing of the formal bail applications, no live recording of the proceedings shall be permitted. This includes the testimony of the witnesses called, the testimony of accused persons, and the respective cross-examination that will follow. The live recording of the bail proceedings will only be allowed after all evidence has been adduced. The closing arguments by the state prosecutor and the defense team may be recorded live. It will also be allowed when the court or the magistrate delivers judgment with regard to the bail applications. By so saying, I do hereby direct that as we are about to start with the evidence of the witnesses, that live recordings be stopped with immediate effect. Failure to adhere to this order, it may amount to a contempt of court. It is now by order of the court. Thank you.
Please, the court.
Your Worship, I'm uncertain as to how long it takes to switch off the cameras, but I'll accept that they are off.
Yeah, just give a space.